Good afternoon, everyone. My name is Kristen Salas. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. For those of you that are not familiar with DVAP, as we affectionately call ourselves, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents uh, with private attorneys that will do their civil legal case from start to finish pro bono. We take a wide variety of cases from family law, probate, expunctions, and one of the common things that we do see come through our doors that we always need help with is consumer law issues. Um, the typical client we see is somebody that has purchased a car, been told that it's a great car, then 2 days later it breaks down, or they've taken their car to get fixed, paid a significant amount of money to get it fixed. Turns out it's not fixed, or they may have had a repair on their home that wasn't done. But whatever the issue is, we see a lot of that come in, and we're always desperate to have attorneys take those types of cases. So if you are interested in taking a case, please do reach out to us and we will put you on our list to get emails about what cases need homes. But today we are going to learn all about how to do the law concerning consumer cases. So today our speaker is Kyle Hansen. He is a commercial litigator with Cozen O'Connor. He's also one of their pro bono coordinators. He got his BA from Arizona State and a joint JD and MBA from the University of Nebraska. And if you do have questions during the presentation, please put them in the Q&A and Kyle will try to get to them at the end of the presentation. So without further ado, I will turn it over to Kyle.
Thank you, Kristen. All right, hello everyone. My name's Kyle, as Kristen let you guys know. And I'm going to be talking today a little bit about consumer law and the DTPA and how and why you should take these cases to protect consumers, specifically those who are not able to protect themselves or may not have the knowledge to protect themselves. So first question is, what is the DTPA? Well, let me figure the slides out. Here we go. The DTPA was enacted in 1973, so it's a little over 50 years old. The primary purpose of the DTPA is to protect consumers against false, misleading, and deceptive business and insurance practices, unconscionable actions, and breach of warranty. The goal of the DTPA is to prohibit and discourage acts and practices that tend to deceive and mislead consumers. Clients requiring pro bono assistance are typically more likely to fall victim to deceptive and misleading business practices. The kind of people we would represent, may not be those that have the same education we do. They may not see the red flags that, would be glaring in our minds. I shouldn't sign this contract. Do I need to read the contract? Things like that. And they can fall victim to a variety of problems and situations that will require our legal assistance. So the DTPA, I'm struggling with that one, protects consumers. So what is a consumer? A consumer is defined as an individual, partnership, corporation, or governmental entity who seeks to acquire by purchase or lease any goods or services. So when you think of a consumer, at least in my mind, it's typically somebody shopping at a grocery store or somebody buying a car. However, the DTPA protects even consumer businesses. So that is something we can consider if there's a small business or, as you'll see here coming up, a larger business such as one that has assets of over 25 million or that is owned or controlled by a corporation or entity with assets over 25 million will not be protected by the DTPA. only consumers and the Texas Attorney General have standing to file a claim under the DTPA. However, as you'll see later on, the DTPA is not the only resource or outlet we can use to protect some pro bono clients when they find themselves in rather unfortunate situations. The DTPA is also very broad, so almost all consumer transactions will be covered. The DTPA provides protections against actions in the conduct of any trade or commerce, which is further defined as the advertising, offering for sale, lease, or distribution of any good or service, or any property, tangible or intangible, real, personal, or mixed, or any other article, commodity, or thing of value wherever situated, and shall include any trade or commerce directly or indirectly affecting the people of this state. I'm not sure they can make that language any more broad. They intentionally wanted to include all transactions to protect consumers and to provide a prohibition on deceptive, fraudulent, misleading actions that consumers can fall victim to. The laundry list. Some of you may have heard of this. The DTPA has a laundry list of now 34 different acts that violate the DTPA in which consumers may sue if the consumer relied on the act to their detriment. This list is ever growing. They'll constantly add new items and lists to it to avoid fraudulent, misleading actions. And because we have an hour here today, follow up, I will go through all 34 acts that violate the DTPA. I'm just kidding, I'm not going to put you all through that. So a few examples of at least some of my favorite DTPA claims, and some that come up more often than not, are number 7 on the list, representing that goods or services of a particular standard, quality, or grade, or that goods are of a particular style or model if they are of another. So this is going to be something you want to know if your client comes to you and they've received a scam product, fake jewelry, technology, and memorabilia. I've been tempted to fall victim to some of these things when you see something you want online. For me, I've chosen to purchase some fake goods at one point or another, but some people will buy them thinking they're real, looking to turn them over for a profit. Consumer tactics such as those are ones that are protected by the DTPA. Number 12 on the list is representing that an agreement confers or involves rights, remedies, or obligations which it does not have or involve or which are prohibited by law. This is a big one for me when thinking about consumers who are less educated, do not have those glaring red flags that pop into their mind when doing business transactions that can really be helpful. When someone signs an agreement, they don't really read it, they don't know what it says, and then you look into the agreement, there's certain rights, obligations, certain things like that that are not exactly how they were presented or how they appear. Those types of situations happen more often than not. As Kristen was saying earlier, somebody that goes and buys a car, oftentimes from hopefully more likely smaller dealers, and say, of course the car works. If the engine shuts down, we'll replace it, no problem. Later on to read the contract that the client may or may not have read that says you take the car as is, any failure of the engine is your responsibility, so on and so forth. Or if a tenant of an apartment complex signs a contract that states, if your water goes out, it's your problem. We're not obligated to fix it or repair it. We all know that that's a violation of the law, and the landowner has to require the apartment to be habitable. However, they may try to fight the issue, particularly in lower income apartment homes, lower income tenants, so on and so forth. Number 13, knowingly making false or misleading statements of fact concerning the needs for parts, replacement, or repair services. This is similar to 12. If you take your car into a mechanic, and if you're at all like I am, where you don't know the first thing about cars, it's easy to hear, oh, you need to replace, insert any car problem here. I'm not a car guy. But I've been to the mechanic, and I've known that from time to time, they are definitely looking to oversell you, get you to buy other items, other repairs, so forth. And if you're living paycheck to paycheck and you take your car in that you need to get to work in order to have income to feed your family, to pay rent, and the mechanic says, oh, we can't fix this unless we fix X, Y, and Z. Now you need to pay double or triple. And next thing you know, you're behind on rent, can't afford food. These are huge problems for lower income individuals, and it's a good place for us to be able to come in and help provide free legal assistance and let them know that they do have remedies available. This one just sticks out as a favorite to me because personally I'm a big pyramid scheme lover. I think they're very interesting, and when I was in college, it seemed like every week somebody had a new pyramid scheme, and every one of my friends was going to be the next get rich quick, top of the pyramid, top of the food chain kind of situation. And I think it's good, but it's funny that the DTPA provides protections for promoting a pyramid scheme. Hey, if you just give us $500, once we get 100 members, we'll pay it back 10 times. I was relatively surprised to learn that people were still falling for this, but last week I did get a Facebook message from an old high school acquaintance guaranteeing me $250,000 a year if I just get in early on his pyramid scheme. And I entertained it because I enjoy a laugh now and again. But other people may not have the education, the knowledge, glaring red flags to say, yeah, I'm not going to make $250,000 a year selling milkshakes. So if a client comes to you and they've been in that situation, the DTPA might provide some relief for them. And 25 on the list, using the term corporation, incorporated, or any abbreviation of those terms in the name of a business entity that is not incorporated under the laws of this state or another jurisdiction. With the rise of social media, online marketing, Craigslist, whatnot, it's easy to see how people can kind of sneak through the cracks and say, Kyle's Car Garage is a licensed corporation. We're incorporated. We're above board business. I can do any of the repairs you need on your car. All you gotta do is bring it to my shop. And as I've mentioned before, I don't know the first thing about cars, and that's not going to stop me from putting that on Facebook, Instagram, any of those things, and selling it at a price half the price of somebody else. And if you're hurting for money and your income is lower, that might seem incentivizing, and people get bid on that all the time, and the DTPA is a good source for those. And I have provided a PDF that lists all 34 of the laundry list of claims that can be used for the DTPA. I believe Kristen or Maricela might have included that in the chat. If not, I can throw it in later, or I can send it out if you want to email me. My email will be on here at the end of the day, or you can look it up in section 17.461 of the Texas Business and Commerce Code. But there's a lot of potential options for filing a lawsuit, and it's worth a read. The good stuff now, damages and remedies under the DTPA. So the remedies under the DTPA are not exclusive, but are in addition to remedies provided in other laws. And violations of certain other laws may also constitute a violation of the DTPA. When you have a plaintiff potential plaintiff, client, pro bono client that comes in and says, hey, I got messed around on a deal. Somebody said they were going to fix my property and they didn't. I got scammed. How do I fix this? They took all my money. What am I supposed to do? There's a whole host of remedies out there. And when you file your petition for the pro bono client, the DTPA is not the end all be all here. You want to go through and find every cause of action you can, whether it's breach of contract, whether it's breach of warranty, fraud, anything like that. You want to throw kind of the whole kitchen sink in your petition and make sure you have all your ducks in a row and have dotted all your I's, crossed your T's, and brought all claims possible for your client. It is worth noting for breach of contract claims, while those can be brought in conjunction with a DTPA claim, there's a little factual argument you have to provide on whether or not the breach was sounding in contract or in tort. That's relatively complicated, but if it also hits under the DTPA, you're more likely than not going to have something that you can at least argue sounds in tort, which will allow you to throw that in your petition and add that to the list of claims against the defendant. The DTPA provides both public and private remedies. So what that means is a private consumer can file a claim against a defendant or a business or a pretend business to seek remedies for any kind of fraud or deceit or misleading. And there's also public remedies for businesses and companies that are conducting these deceptive practices and misleading consumers on a larger scale. And with the public remedies, you may get a pro bono client that you're representing and you're looking at their case, you're looking at the facts, and you think, gee, this business is shady, or this person is just a scam artist. And it's always worth researching when you get a case like this to kind of see what the defendant is up to. What are they doing? Is this the kind of action that seems isolated? Is it a general, bad practice where they're looking to take advantage of anyone and everyone that comes by their shop or purchases their products or services? And if it's wide scale, it's worth researching and reaching out to try to find if there's other consumers out there that are being harmed and damaged by this person or business, and you could potentially have a much larger case on your hands, which, depending on your caseload, could be good or bad. But these cases are fun because when you dig in the weeds, it seems like you can always kind of find something else that's going on, or uncover something under one of the rocks you're looking through that can lead you a little bit down a rabbit hole. But again, I think as attorneys, we all like sticking it to the bad guys. So these cases are fun in that aspect. So public remedies are enforced by the Consumer Protection Division of the Texas Attorney General's Office. The remedies available are temporary restraining orders, temporary or permanent injunctions, and monetary penalties of up to $20,000. If you wish to report a DTPA violation and seek a public remedy, you should contact the Consumer Protection Division of the Attorney General's Office in Austin, Texas, or in larger cities such as Dallas, contact the local Attorney General's office. Private remedies. Under the DTPA, a consumer who files a lawsuit is entitled to recover economic damages, whatever amount is lost in whatever deal. If you overpay 2 or 3 times for a muffler, you can seek the recovery of those damages. And if the wrongful act was committed knowingly, you may be awarded up to 3 times the economic damages and for mental anguish. So this is where the DTPA decides to kind of strike hard on businesses or persons who are, really trying to deal fraudulently, and they know that they're acting with fraud or to deceive or mislead consumers, and kind of steeped up the damages that a consumer is entitled to. 3 times the economic damages for the types of clients we represent, a pro bono case. Now, that could be a huge setup for them. If your client lost $1,000 and they bring in $1,200 a month, and you can turn it around and get them 3.5, 4 grand, you'll be their favorite lawyer, and I'm sure they'll tell all their friends about you again, whether you want that or not. Maybe your own prerogative, but it should make you feel good. And next, was the act committed intentionally? An intentional act would not only allow you to seek 3 times the economic damages, but the court may award up to 3 times mental anguish damages. And as I mentioned a few times already in this presentation, when we're dealing with people who have lower incomes and are stretched from paycheck to paycheck, the argument for mental anguish damages can really, really add up. If you have a family to feed and you're struggling to do that, if the fraudulent or misleading act caused you to miss rent and incur late payments, to potentially be evicted from your home, the stress of providing for a family that you're unable to provide for due to the intentional act, we can definitely craft an argument here to get a good payday for our clients. So knowingly or intentionally. The way to determine this is done on a case-by-case basis through considering all the facts and circumstances relating to the transaction. But it's important when you're filing your petition to assert this key language in the petition that the act was done knowingly or was done intentionally. And it will be a factual argument, but when it comes time to discussing the case with the defendant's counsel or looking for a settlement, these keywords are what really hike up the damages and can get the best result for our clients. So in Texas, knowingly would be defined as acting with actual awareness of the falsity, deception, or unfairness of the act or practice giving rise to the consumer's claim. And the actual awareness can be inferred from objective manifestations that indicate a person acted with such awareness. So when you're looking at this and you have your client coming to you saying, I know he tried to get one over on me. I know he was lying. He knows that he was lying. It's a little bit of a balancing act here. It's not so much as, did the person know what they were doing? Yes, the person likely knew that they had the consumer purchase a car using a boilerplate contract. Now that's not going to reach the threshold of knowingly acting with the awareness of falsity or deception. But if they know what they're doing is false, then that would bring this in and allow you to get those 3 times economic damages, which is not too difficult to prove when dealing with shady characters who may or may not have committed these acts or similar acts to other consumers, who know that when you sell somebody a car and you provide no recourse if it's a lemon, or if you say you're going to fix somebody's house and you go in there and cover up a hole and don't do any of the work, you know what you're doing. And that's an argument that's relatively easy to make. And then to get 3 times mental anguish damages, alleging that someone intentionally deceived or intentionally misled a consumer You have to show actual awareness of the falsity, deception, or unfairness of the act or practice or condition, defect, or failure constituting a breach of warranty. And it also must be coupled with a specific intent that the consumer act in detrimental reliance on the falsity or deception, or in detrimental ignorance of the unfairness. So this is where it comes into a little bit of a balancing act on, who holds the power. And again, in our current situation, talking about pro bono clients who may not be well educated, they may not have the business wherewithal to see the red flags. It's not going to be uncommon for them to deal with certain business characters or certain people trying to sell goods or services that are intentionally looking to get one over on somebody that may not, one, they may not know better, and two, the actor may think they're not going to file a lawsuit. They don't have the money to pay for an attorney. And those are the cases where this will come in and really hike up the damages. And again, why DVEP is a good program, because it allows us to come in and provide these resources for free to those people who normally wouldn't have the funds to file a lawsuit. And the good news is, if your client is a winner, the consumer is awarded cost of court and reasonable and necessary attorney's fees. So for us, and slightly selfishly thinking, we can kind of double dip here on our pro bono hours. And if our client ends up winning, then we can still collect our attorney's fees, and then everybody wins, and it's a happy day, and you can move on and have a little money in your firm's pocket, which everybody loves. Defenses against the consumer. So one of my favorite movies, Flubber. While these causes of action and the DTPA are a great resource for providing relief and allowing our potential pro bono clients to have remedies, we do need to be careful and ensure that we don't get too overzealous and that our client doesn't get a little greedy and we find ourselves, as Robin Williams' character did in Flubber, diving and dodging to avoid the bounce back effect of a DTPA claim. So bad faith claims. If the court finds that an action by a consumer was groundless or brought in bad faith or brought for the purpose of harassment, the court shall award the defendant the cost of court and reasonable and necessary attorney's fees. I've been in situations, and if you take pro bono clients on in situations such as these, they are rightfully more likely than not going to be vengeful. They may not always tell you the truth, as we know, and may try to manipulate the facts a little bit in order to make their claim seem more probable or more likely to succeed. And as attorneys, we need to be careful to flesh out the facts and verify that these claims do have merit and that they're not brought for revenge or as a form of harassment to, it could be an ex-lover of your client. It could be a family member who the client just is upset with for one reason or another. Maybe they felt wrong, even if they weren't, and they want you to bring a claim on their behalf to, get their pound of flesh. And we just need to be careful to make sure that all the claims have merit. Sure, we always do, and that it can't be turned around and brought back against us to where we'd have to pay the defendant's cost of court and their attorney's fees. Failure to settle in good faith. So under the DTPA, either party is allowed to maintain a court order where they're required to mediate. And the defendants may offer to settle up to 90 days after the defendant files an answer to the consumer's petition. If the settlement offer is found to be the same or substantially the same as the actual damage is found, the defendant will have a defense to the additional damages provision of the DTPA. So, essentially, this is the legislature's intent to promote settlement of these claims. While we all love to pick a fight sometimes, and we may want to go after a business or person who is defrauding and manipulating and misleading innocent consumers. If the defendant is willing to settle, you need to keep this in mind and be reasonable with that. And you need to inform your client from the onset that what are you looking for? What's the settlement offer you're going to be happy with? And then inform them of the realities of the law and that they can't get $1 million because somebody failed to fix their car properly, or somebody sold them a lemon for $4,000 that was worthless at the end of the day. The defendant is allowed to offer to repay the actual damages from the onset, and if within 60 days, if they offer the full amount claimed by the consumer, including expenses and attorney's fees, so we win again, that is a complete defense to a lawsuit filed under the DTPA. Again, if you have various other claims, this may not seem like a viable option for the defendant. They may be less likely to settle. But if your claims sound purely in the DTPA, looking for an early settlement is usually a good move. And I forgot to include it in the PowerPoint. The 60-day period mentioned for the defendant allowed to offer the full amount claimed by the consumer as a settlement. That is the 60-day period from which a consumer is required to notify the business or defendant that they believe they have violated the DTPA and that they will pursue a claim if the defendant does not respond within that 60-day period. And the consumer cannot file the claim within that 60-day period unless it is required to do so in order to avoid a statute of limitations issue or statute of limitations, or for some other reason it's required to be brought, even if it's for a breach of contract and it needs to be brought within that time frame. That kind of situation will waive that 60-day wait period for a consumer to file the claim. Speaking of statute of limitations for the DTPA claims, so the statute of limitations for the DTPA is 2 years, just as with tort, trespass, products liability, and property damage. Where this is important is if you get a client and they come to you and say, I've been wronged, someone got one over on me, I made a bad business decision, I was scammed, and the alleged scam or deceit took place 2.5 years ago. Well, unfortunately, the DTPA claims the statute of limitations have ran, and while that may not be viable, you can get creative and you can look for, was there any fraud? Was there any breach of contract? And you still can file a claim on behalf of your client and still look for some redress that way. And this is an important thing to do when you're first talking with your client, is to really flesh out, okay, what happened? When did it happen? Was there a contract? You can get creative. There may have been an oral contract. Inform them again. Not a lot of people will know that I agree in an oral contract. Was it a conversation? Those are the kind of things that you'll really want to learn in your initial conversation with your client. And if there's a statute of limitations issue, you can be a little creative and look for other actions to still try to get some redress for your client. All right, so when we do get a client in a consumer law case, and we believe they have a claim in any manner but within the DTPA, the 2 first things you should do: 1, meet with your client and advise them of the situation. It can be beneficial to have a one-on-one, face-to-face meeting with your client to allow them to really tell their story, for you to verify their credibility, and to flesh out all the facts possible. Just as I was talking about, when did the action occur? Is there a statute of limitations issue? What are the damages? Is there mental anguish? What happened as a result? How did you get in contact with this business or this person? Who deceived you? And those face-to-face conversations tend to be more fruitful than a phone call or simply jumping online on a Zoom or a Teams meeting. However, I know that it's much easier to jump online for a Teams meeting than it is to meet up with a client in person. But in these cases where somebody really feels wronged, just simply letting them know that they can come into your office, sit down, and really let you know the true story of what happened. I find more often than not, a client will be willing to do that, and it can really help build that relationship, and it'll help you really figure out the facts and the circumstances of what's going on. It's easier to kind of shortcut a story when you're on Zoom or on Teams. When you're face to face, your client's going to be more often than not likely to talk, maybe talk your ear off, but you'll get as much information possible out of it. And if the client tells you the story and you're sitting there thinking, this may not be a winner here, I don't really know if I can help or if this is going to be successful. We're in a position to still provide assistance and inform them and educate them just on basic, what we would probably say is common sense, but let them know moving forward, read your contracts. If something seems too good to be true, it probably is, and inform them of the public resources that they can use to verify that they're not working with a shady person and that this company will actually fix their problems, or that they're not going to get manipulated or jousted out of however much money they're paying for their good or service. A quick social media search, Google, word of mouth, talking to friends and family, Yelp, Better Business Bureau. All these things to us may seem obvious to verify and check in before we make a business decision, but other people may not have that same knowledge and education. And whether or not our lawsuit's going to be a winner or a loser, it's important to still provide this assistance and let them know moving forward, yeah, I wouldn't get in this deal unless I verified, is this a real accredited business? Do you know anybody that's used this service? Are you buying a $1,000 purse for 20 bucks? You may want to consider how logical that may be, and just educate them a little bit and help them out moving forward. And you may not know one way or the other whether they take your advice or not, but if they find themselves saying no to a business transaction, later find out that it's a fraudulent business, or maybe one of their friends was misled and lost some money, they'll be very happy they talked to you. And again, their word of mouth for you as an attorney will be beneficial. And the second thing is to talk with the opposing counsel when you do file a case. If the defendant is represented, you can inform the defendant or the defendant's counsel that you're representing the client pro bono. This can be beneficial because, as I said earlier, a lot of defendants, probably those who are attempting to take advantage of a person in a smaller position of power or with less power, they're gonna believe that this person is not going to have the resources to provide or to obtain sufficient legal services and legal assistance. So letting the defendant's counsel know, or the defendant know, hey, I'm good at what I do, I'm representing my client for free, where you're not going to get out of this by motion practice. It's going to cost a lot of money. We'll see this through for my client, and we're going to get to the proper resolution. That can position to the defendant or the defendant's attorney, okay, this thing's here to stay. We're gonna have to really look into this, and that might incentivize them to settle. And it might scare them a little bit, for a lack of a better term, that, we are here. We're gonna work this case up, and we're gonna do everything we can to protect our client. And that may mean 3 times economic damages. That may mean 3 times mental anguish. And if they know that early on, they're going to start looking to, okay, how can I get rid of this? How can I settle? What's the number I have to give out there for this to go away? Not only to maybe avoid those potential 3 times economic damages, 3 times mental anguish damages, but also to avoid paying their own legal defense costs. And having those discussions early, can streamline getting your client's problem rectified, getting them paid or recouped, or getting their house fixed or their car repaired. And it's a win-win for everybody. Now, why should you take a consumer law DVAP case, or incentivize some of your colleagues and coworkers to take a consumer law DVAP case? The obvious, you're helping people in need who have been deceived or misled. That's always something fun to lay your head down in bed at night. I really helped this person out. They're down on their luck. They got the raw end of a deal. And I took time out of my day and was able to help them. That's the given. And that's something you all are probably interested in, being that you're attending a DVAP CLE. So another good reason is it's good experience for young attorneys. And I fit the bill for a young attorney, and I've been allowed to work on these consumer law DVAP cases, and it is good experience. It gives us a case that we feel like we can run with. It's speaking with clients that aren't owners of businesses, CEOs, experts in their field. It's more personable conversations, less legalese, and it helps build confidence in, okay, I can take a client interview. Okay, I can file these motions. I can respond. I can talk to defendant's counsel and start initiating settlement discussions and conversations. And it can be very helpful to build that confidence in a young attorney, while, again, the obvious, helping somebody that's in need, who's been deceived or misled. It also is a good way, if the defendant or defendant's counsel wishes to push the case all the way through trial. It's a good opportunity to have first chair civil trial experience. It's relatively lower stakes. You don't have a client that's going to get mad at you. Partner's probably not going to fire you if you don't win a pro bono case. And you can go to trial and speak to the judge and get experience that way. And again, it's a good way to build confidence and help somebody out in the meantime. And third, and probably not the most important, but one of my favorites, is these types of situations, more often than not, include interesting characters and interesting stories. My first consumer law pro bono case was a nice young lady, mother of 2, met what she believed was the love of her life on Tinder. And he convinced her to loan him money for his business, to which he would repay. And then that turned into him her loaning him money to repair a jet ski for profit that he would then repay. And then to loaning him money to buy a new pickup truck that he would use for work to make more money, to which he would repay. All of which, as you can imagine, never happened. And then he ghosted her. So she came to us, and we worked with DVAP and decided to file a case on her behalf. And all of these issues I talked to today came into play. Was she a consumer? Does she have a claim? Was there a contract? What's the statute of limitations? And we did all the legwork. We filed the complaint. And out of nowhere, I got a phone call from another young lady who had the same situation happen with the same gentleman. And then the next 2 weeks, it was 3 or 4 phone calls from other women, phone call from an ex-husband. And it turns out that this guy was a serial Tinder swindler. If you all have seen the Netflix documentary, it was a lower level scheme, but the same basic idea. He was manipulating these women, getting money, and then ghosting them. And as I've mentioned before, he thought there's no way they're going to sue me. They don't have the money to hire a lawyer. We don't have an active contract. I'm good. Unfortunately, our client did end up getting a job and did not reach the or did not satisfy the pro bono client standard. And unfortunately, this defendant had thousands of dollars in unpaid child support. So again, in my initial conversations, we let her know that, hey, we can file this claim, we can try to get you a judgment, but the likelihood of you ever being paid on this is pretty low. So that, coupled with her not being indigent or available for pro bono assistance, she allowed us to drop the case. And about a month or two ago, she did reach back out and let me know that this defendant is going to be on a documentary discussing people who are scamming girls on Tinder. And I'm waiting for that to come out, and I can't wait to watch it because it's plenty of drama. And if you like drama, cases like these can be fun. I can't tell you the details, and I'd have to be here all day, but reading through the text messages and conversations were very interesting. And it's a little bit of a breath of fresh air reading through dramatic text messages rather than contracts or motions or document reviews. So there's some fun in these, and I advise you all to take some of them on, and I have no doubt that you'll have a good time. All right, and does anybody have any questions? I see something. I'm just looking in the chat now. Christina, I see your question here. What if the entity fraudster is not based in the United States, but they're pretending to be associated with a US company? Any recourse? I do not know the specific answer to that off the top of my head. That does seem a little specific, and I don't want to give you an incorrect answer. I do believe that if the consumer is a resident of Texas, the DTPA would still apply. I do not know if the DTPA or Texas law will be able to reach a foreign entity or fraudster, much less attempting to try to find them to serve them, to get a judgment off of them. Those are one of those difficult situations that may not always be winners, but if we get a pro bono client and they're feeling hurt and wanting a some sort of recourse, you still can file a claim. You can try to serve the entity or fraudster. You can allege all these causes of actions, and maybe it'll scare them a little bit into maybe they'll reach out for a settlement. Maybe they'll go under a rock and hide, but you still can swing for the fences, just knowing that it's not always going to be a home run. And the next question is Sanford. Under the DTPA, are bad faith claims only evaluated on the basis of financial value, meaning if the most important thing to the consumer is that the defendant's actions are made public or their liability is actually determined, can they be forced to settle, thereby foregoing confidentiality or defendant deniability? Again, that's another good question. And I'm not sure. Again, I'll look into both of these and I can reach out to you all. Here, my email is supposed to pop up. And I'm not sure what the stipulations are for requiring a settlement. Based off the DTPA, if the defendant comes to the case and says, here's your economic damages, I'll give you those back, and I will, I'll pay for your expenses, cost of court. I'm not sure that the DTPA will require them to forego a confidentiality or disparagement clause in that settlement. That'd be something you'd have to work out likely with the defendant's attorney. And again, I'm just not sure on the specifics as for if that would, still fall as a defense for their claim or, forego the additional damages section of the DTPA. But I'll look into that, Sanford, and I'll, and Christina, I'll look into both those questions. And if you all want to email me, I have my email here. Just as a reminder, I'll look into those and get back to you and see what I can find to give you some more tailored and specific advice.
Thanks, Kyle. Any additional questions, please feel free to include them in the Q&A box that's located on the bottom of your screen. Let's see, I think we might have another one.
Yeah, Nia just asked a question. What do you recommend we do if we need to serve an entity that is now defunct? Again, as I've mentioned a few times in this presentation, not all of these cases are winners. And, there's still possible recourse you can have there on whether, again, it depends on the factual specifics on if that entity just shut down, if there's a sole owner that you could maybe pierce the corporate veil and attack them personally. If they were usurped or acquired by a separate company, you could attempt to go after them. Some of these DTPA cases, and it may seem frustrating, but I think it's why it's fun, is sometimes you have to get a little creative and think outside the box to find some solutions. And again, a lot of these defendants, at least in my experience, are not going to be above board and ready and willing to pay. So you have to go in there with the expectation, and I think it's best to inform the client from day one. Look, we may not be able to reach this defendant. We may not be able to get a judgment, even if we can reach the defendant, improve our case. And so it's always best to make the expectations legitimate and realistic. And then, as I said, you search outside the box to see any way you can try to tie somebody to the transaction and find anybody related to the deal that you can. All right, and then anonymous attendee. Have you found yourself working with law enforcement to make your case or to support their white collar cases? I personally have not done that. It's not a terrible idea if you believe that there are illegal activities and criminal activities involved in the fraud or deceit. It's, again, using all the resources at your disposal to help your client out is always a good move. And the police is definitely an option that can apply pressure. And if it's a character that they're really looking at and wanting to go after as well, you may have some additional information to help them, and it never hurts to work as a team.
Thank you, Kyle, and thank you for everyone for your questions. Any additional questions, I will be sending out a copy of the slides with Kyle's email address so you can connect with him directly, as well as Kendall Hayden, who has mentored plenty of DVAT volunteers in the past and continues to do so. Just want to do a quick housekeeping for those who need their MCLE course number. That number is 174-241 174-241-070. Again, that is 174-241-070. I will also be emailing that course number for anyone who needs it. But thank you everyone for attending today's session. Thank you for Kyle for presenting. And if you are interested in volunteering with DVAT, please feel free to reach out to myself and or Kristen, who presented earlier. And we wish you a great rest of your afternoon.
Thank you everyone for having me.
Thanks everyone. Bye.